Lots of these sorts of issues crop up in the court of protection, and given the significance of sexual freedom as well as being free from sexual abuse, it's often judges that have to grapple with this sort of complex issue. So this is what we're going to cover in the next sort of 30 minutes or so. It'll be a sort of whistle-stop tour of quite a big topic. I'm going to start with the importance of supporting people to make their own decisions. So one of the foundational principles of the Mental Capacity Act is the need to take steps to support someone to make their own decision. So we'll look at that in the context of a particular human right, Article 8. We'll then touch on the interface between sexual capacity and the criminal law. And in particular, I'll just briefly go through some aspects of the Sexual Offences Act so that you can see how the consequences of incapacity could then give rise to potential criminal offences. We'll then look at how to determine mental capacity in the context of a recent decision of the Supreme Court in JB. JB is the sort of leading case now when it comes to sexual capacity. And then finally, I'll say something about the fairly limited role that best interests has to play. And I'll talk you through what's referred to as a TZ-style support plan, which essentially is something that we are encouraged, if not required, to design in a situation where you have someone who is able to make decisions around sexual relations, but lacks capacity to make decisions about contact. So that's the plan. And just to put this into a particular context, as with many things, I suppose, in life, the law is all about striking a balance here. And the courts have referred to three sort of fundamental principles of public interest. The first is, of course, autonomy. We've heard about autonomy already. It lies at the heart of the Mental Capacity Act, the case law, as well as in international law, the UN Convention on the Rights of Persons with Disabilities. And autonomy is, of course, important, but so too is the need to protect vulnerable people. And so, for example, if you look at the Code of Practice to the Mental Capacity Act, it says it's important to balance people's right to make a decision with their right to safety and protection when they can't make decisions to protect themselves. So it's not all about autonomy. Autonomy is not a sort of one-way ticket. There's also a need to balance that up with the right to protection. And then this is part of a wider sort of system of law and justice whereby sexual relations can only take place with the full and ongoing consent of both parties. So those are three sort of basic foundational principles for what's to come. And then in practice and in law, it's about balancing the right to sexual freedom on the one hand versus the right to be free from sexual abuse on the other. And that can be an incredibly difficult balance to strike. We have both the Mental Capacity Act, civil law, as well as criminal law, both of which aim to both empower and protect vulnerable people. So, as we'll see in a moment, the Sexual Offences Act criminalises certain aspects of sexual relations with those with mental disorder, and for these purposes that would include intellectual or learning disability. But then also the Mental Capacity Act expressly prohibits a best interest decision on sex. And so in this scenario, capacity to make decisions about sex is an incredibly significant assessment. Of course, generally assessing someone's capacity is always going to be important. But in this scenario, it's particularly important because if it's proven that the person is unable to make decisions regarding sexual relations, then that's the end of it. There can be no best interest decision. No one can decide that it's in your best interest to have sexual relations with another, because the MCA expressly prohibits that. Okay, but what it doesn't prohibit is decisions around contact. And so hopefully straight away you'll see that this talk is very much not just about sex, it's about contact. And I'll cover sex first, and then we'll have a look at contact. So starting with practicable steps and Article 8. We're all familiar, hopefully, with the 5 principles of the Mental Capacity Act. So from the age of 16, which is when most of the Mental Capacity Act kicks in, there's an assumption, regardless of any condition someone might have, there's an assumption, our starting point is to assume that they are able to make this decision unless it's proven otherwise. But I want to focus on the second principle, which says that a person is not to be treated as unable unless all practicable steps to help them decide have been taken without success. Now, we don't have a lot of case law on this one, but there is one particular case that's of interest, which is CH. And that involved a 38-year-old married man with Down syndrome and learning disability. And within the marriage, the couple were seeking fertility treatment, during the course of which a psychologist considered, assessed, and determined that the man lacked capacity to make decisions around sexual relations. And on the back of that, given that a potential criminal offence might then arise if the married couple were to have sex, the local authority wrote to the couple and basically said it would be a criminal offence for the wife to have sex with her husband. But, and this is what the case was all about really, the psychologist had recommended that sex education be provided to the husband. That was seen as a practicable step that needed to be taken to try and max out his ability to make that decision. And there was a 12-month delay. No sex education was provided. The couple were effectively required to be asexual within their relationship, which is obviously a massive interference with their right to respect for private and family life. And the court decided that there was a breach of this principle. The failure to take those steps was a breach of the Mental Capacity Act, a breach of Article 8, and then compensation was awarded. And in that case, the husband was awarded £10,000 for 12 months of effectively unlawful celibacy. And then you've got the other principles, which I won't go through, the one about unwise decisions, best interests, and having regard to what's less restrictive. So hopefully those 5 principles are very well ingrained. And I want to have a look at Article 8 in a bit more detail, because obviously we are all, whilst at work, we are all public authorities. So even if the Bill of Rights goes through, and we'll see about that, we will still be signed up to the European Convention, and one of those convention rights is Article 8. So this is the right to respect for private and family life. And whenever you might be involved in decisions around contact or sexual relations, it's important to think about this human right. So it says that everyone has the right to respect for 4 areas of their life: private life, family life, home, and correspondence. But this is a qualified right. It's not absolute. In other words, public authorities, like in that case I just mentioned, can interfere provided they act in accordance with the law and what they're doing is necessary and proportionate for a legitimate aim. And of course, in the CH case that we've just seen, they failed to act in accordance with the law because they failed to provide practicable steps as the Mental Capacity Act required. So that's Article 8. And there is case law. We don't really need to go into it in a huge amount of depth, but basically the European Court and English courts have said that sexual life falls within the personal sphere that's protected by Article 8. Article 8 protects the right to personal development and the right to establish and develop relationships. So Issues around contact between one person and another, issues around sexual relations, these are significant Article 8 issues. But there is a balance to be struck. So let's just quickly have a look at the Sexual Offences Act. We don't need to go through it in a huge amount of depth, but essentially, as you can see, there are various provisions that criminalise certain behaviours. So it starts off with issues of rape, assault, where there's a lack of consent, and then you have sections that deal particularly with scenarios where one person has a mental disorder, which, as I say, would include intellectual or learning disabilities. So sections 30 to 33 criminalise sexual activity with a person with a mental disorder impeding choice. 34 to 37 criminalise the inducement of sexual activity of those with a mental disorder. And then 38 to 44 relate to care workers in particular and criminalise sexual activity, again, with a person with mental disorder. So those are some of the key criminal offences. And the Sexual Offences Act at the bottom there says that a person consents if they agree by choice and have the freedom and capacity to make that choice. So notice that capacity, therefore, is pretty critical when you're looking at the potential interface with the criminal law. In CH, the man was deemed to lack capacity. The husband was deemed to lack capacity to have sexual relations with his wife, and therefore it would have been a criminal offence for the two of them to engage in sexual relations because he lacked capacity. The other significant potential consequence of concluding that someone lacks capacity to make decisions about sex is what I refer to as the Iron Curtain, where they said that the significance of this decision around sex should not be underestimated. If there is a declaration that the person lacks capacity, the local authority must undertake the very closest supervision of that individual to ensure, to such extent as is possible, that the opportunity for sexual relations is removed. In other words, if the evidence shows that the person lacks capacity to make decisions about sex, then this would indicate that the weight of the state then needs to sort of step in to try and ensure that nobody is able to have sexual relations with that person, because that would be a crime. Now, personally, there are some concerns, let's say, about whether this is a proportionate step to take in terms of bringing down this Iron Curtain to try and prevent sexual relations. But that's the case law at the moment, and certainly local authorities will be very conscious of that paragraph, because it seems to suggest that if a psychologist, for example, or a psychiatrist were to establish a lack of capacity for this decision, then we're under a positive duty to sort of step in. And you can imagine how restrictive the arrangements would have to be, let's say in a supported living context, to prevent any risk of sexual relations. The person is effectively rendered asexual. It's a massive step to take because, as I say, no best interest decision is permitted, even within a marriage. So let's then look at capacity in a bit more depth. In Chambers, we've provided various guidance notes which are all freely available, and by all means have a look at them. There's one at the bottom here on the law relating to capacity generally. Top left, there's one that gives you some guidance about what information is relevant to different decisions. Now, obviously, we're focusing on contact and sex, but we've got guidance on all sorts of other things, such as medical treatment. And then there's some guidance specifically in relation to fluctuating capacity. So there's further reading there if you wish. But let's have a look at JB, which was decided by the Supreme Court at the end of last year. Now, this was the first time that the Supreme Court had the opportunity to consider the test for mental capacity, generally. The case itself concerned a man with autism who wanted to have sex with someone, anyone. And the decision is important for a number of reasons. The first relates to capacity more generally, because the court emphasised that whenever you are assessing someone's ability to make any decision, including, residence, medical treatment, contraception, whatever the decision might be, you have to start with the functional test. And I think sometimes, particularly in hospitals, perhaps there is a lack of confidence in assessing capacity. Maybe there's a lack of confidence in using these provisions of the Mental Capacity Act. So we are well advised to start with the functional test. You look at whether or not the person is able to make a decision in relation to this matter. Okay, you don't ask or start with, do they have a learning disability? That's irrelevant. That comes later. That's discriminatory. You start with, are they able to make a decision for themselves in relation to this particular matter? And again, hopefully this is all fairly familiar. There are sort of 4 limbs to this. Parliament has tried to describe in law how all of us make decisions in life. So when faced with a matter that requires a decision, we need to understand the information that's relevant to that, including the foreseeable consequences. We need to retain that long enough to decide. We have to be able to use that and weigh that as part of the decision-making process. And then finally, we have to be able to communicate our decision. So that's what we start with. And it's important, of course, to carefully identify what the decision is, which is not necessarily straightforward, but that's what needs to be done. And then from that, we can work out what information is relevant. Now, Dr. Todd will talk about executive functioning later on, which relates to that third limb in many ways. Situations where perhaps someone can understand, they can retain, but the question is, can they then use or weigh what they know? Okay, but I'm going to look in particular at what the information is that's relevant to decisions around sex. So it's functional first. Okay, that ensures it's a less discriminatory approach that's taken. And if, for example, in practice, because usually there will be some sort of template or form to evidence a capacity assessment, if it doesn't start with the functional test first, then be wary. Okay, so functional first. And it's only if the person is proven to be unable to make the decision do you then ask whether they have a mental impairment, such as a learning or intellectual disability. And then thirdly, is that the cause? Are they unable to decide because of that? So again, hopefully that's all pretty well ingrained and pretty straightforward. But what we need to think about is, what is the matter that requires a decision in this context? Is it contact? Is it sex? And what information is relevant? Now, for JB, the evidence suggested that he could understand, retain, use and weigh up a lot of information that's relevant when it comes to sexual relations. But what he was struggling to understand was the importance of the other person providing consent. The evidence was that, well, his goal was to have sexual contact with any woman, and he didn't understand the need for there to be ongoing consent to that sexual activity. And so the court was asked to look at the law, and there's a lot of law in relation to sex, believe me. And I've just pulled out some of the key messages really that come from that case. So firstly, they emphasised how we need to carefully formulate what the matter is that requires a decision. For example, are you looking at someone's ability to make decisions around sex in general? Or are you looking at their ability to make decisions around sex with this particular person? And they said that usually capacity is assessed here on a generalized forward-looking basis. Okay, so the usual position in these sorts of cases would be to assess their ability to make decisions to engage in sexual relations rather than with a particular person. Okay, so usually it's forward-looking and it's quite a general approach. But importantly, they said that sometimes the context requires this to be more person-specific. So rather than capacity to decide on sex generally, it might be more focused on a particular relationship. And they gave a couple of examples. So a couple who have been in a long-standing relationship where one of them develops dementia or a brain injury, or for that matter, learning disability. If there's a scenario where you have a couple and let's say one or both have a learning disability, that might be a context where we take a slightly more nuanced approach to capacity assessments, which I'll talk about later. Another example they gave is where you have two individuals who are mutually attracted to one another, but who both have cognitive impairments. So that's when it could be more sort of person-specific, and that's important because it can affect what you need to know. And they said, secondly, you need to identify the information that's relevant. And then thirdly, functional test first. So what information was relevant for JB's decision to have sex with any woman? Well, they said you need to grasp the sexual nature and character of the act of sexual intercourse, including the mechanics. Second, and critically for this particular person, the fact that the other person must be able to consent to sex and must in fact consent before and throughout the activity. That's the bit that he was really struggling with. And so at the moment, he lacks capacity to make this decision because he cannot grasp the importance of that piece of information. Third, they said, you need to be able to grasp the fact that you can say yes or no to having sexual relations, and you can decide whether to give or not give consent. So you have a choice. That's incredibly important. Certainly some cases I've dealt with, the person at the heart of the case doesn't realize that they can say no, and therefore might lack capacity as a result. Fourth, a reasonably foreseeable consequence of sex between a man and a woman is pregnancy. And fifth, the health risks involved, particularly the acquisition of sexually transmitted and transmissible infections, and the risk of STIs can be reduced by using a condom. So if you were required to look at and assess someone's ability to make a decision to engage in sexual relations, these are the 5 things that you would really be focusing on. Can I understand, retain, use and weigh those 5 things? If, however, the context is more person-specific, let's say I'm in a relationship, then it might be that some of these things actually are not important and we can ignore them. So, for example, if I was in a homosexual relationship, you can forget number 4. I don't need to understand number 4 because it's not relevant. Similarly, if we were looking at a situation where it's a heterosexual relationship, but maybe the woman had been through menopause, well, again, number 4 is not relevant. In the CH case, they didn't really talk about this in a huge amount of depth, but in CH, where it was a monogamous marriage on a more person-specific basis, it might well be that the actual risk of him acquiring a sexually transmitted infection from his wife was virtually negligible. Yeah. And of course, like, this is all critical because the more at stake, the more you need to comprehend, the more likely you are to lack capacity. So that's why JB is important when it says that, well, it might well be a sort of generalized forward-looking approach that we take, but equally there could be situations where we need to be much more tailored and nuanced in terms of the information that's relevant. So that's the leading case when it comes to information that's relevant on decisions to engage in sexual relations. Now, best interest is excluded. If the person lacks capacity to make that decision about sex, as I said, that's the end of it. They cannot have lawful sexual activity because they cannot give valid consent, and therefore sexual activity would be a criminal offence. That's why there's so much at stake with these sorts of capacity assessments. So is there any role for best interests? Well, personally, judges, let me start with the judicial approach. Judges have basically siloed contact from sex. They see those as two separate decisions. They think that sex is a very simple decision, whereas contact can be much more complicated. And so they tend to approach those as two separate matters. Now, personally, I think it's quite difficult to have sex without contact. And so what I would suggest, if you're faced with this scenario, is that you start with contact. Does the person have capacity to decide to have contact with this particular person? If they lack capacity around contact, then best interest decisions can be made in relation to contact. So I think it makes more sense to start with contact capacity. And if you are dealing with a situation where that a reasonably foreseeable consequence of contact is sex, then you can look at sex later. Okay, so start with contact. And again, judges have set out information that's relevant when we are making decisions around contact. So you need to be able to understand, retain, use and weigh up who that person is, and in broad terms, the nature of your relationship, what sort of contact you're going to have with this particular person. And that's potentially where sex might come in, of course. So what sort of contact? The positive and negative aspects of having contact with this person, and what might be the impact of having or not having contact. And then finally, if we're talking about contact with a family member, you do need to grasp the nature of that family relationship. Okay, so that's the information that's relevant. These are the salient details that people need to grasp when it comes to deciding to have contact with a particular person. And personally, as I say, I think it makes sense to start with that. Do they have capacity to have contact? If they don't, well, then we can get in the world of best interests. And if we really do need to look at capacity around sex, so be it. Okay, but approaching it in this way, I think, minimizes the sort of risk of that big sort of iron curtain. Now, judges, as I say, they've separated contact from sex. And so TZ is an important case because it sets out what we're expected to do, where you have a situation where someone is able to make decisions about sex, but is unable to make decisions about who they have sex with. So they have sexual capacity, but lack contact capacity. And basically, in this particular case, this man had capacity around sex, but couldn't make decisions about whether or not someone with whom he might want to have sex with was safe. And he also lacked capacity to make decisions about the support he required when having contact with an individual. And so in that context, the judge said the aim in this scenario is to use best interests in relation to contact to try and empower and facilitate sexual freedom. So you're using the concept of best interests here to try and empower and enable the person to be able to exercise their sexual freedom, but in a safe way. And so if you've got a case where they lack contact capacity but have sexual capacity, we tend to develop this sort of TZ style support plan. And there are various headings, which essentially, the way I sort of look upon it is it's a support plan to try and enable the person to find a safe partner, basically. So in this particular case, the first aspect of the support plan was around education empowerment. So he would have a named worker to oversee an education program to help identify and assess risk. He would also get some advice and support from LGBT groups, and the plan provided for a program of social activities, going to pubs, cafes, clubs, whereby the staff would first check to see if the environment was safe for this man. In terms of the support that would then be provided, so that's the second heading, the plan would specify the amount of one-to-one support he would have, and he would have support to assess, and the staff would then step back if they felt that he could manage the situation safely, recognizing that he must have space to make mistakes so as to learn from them. And the judge emphasized that the staff cannot be sort of interviewing or vetting potential partners. Instead, they should only intervene if there really was a risk of this person being abusive to him. And then the next aspect of the support plan, it sets out the circumstances in which the care staff can intervene to protect him. So notice again, it's about striking the balance between sexual freedom versus being free from sexual abuse. And then finally, a support plan like this would set out details of decision-making and reviews in this most sort of intimate aspect of Article 8 rights. So we've looked at the importance of practicable steps, which typically involve sexual education, although there might be other steps that, of course, could be provided. We've looked at the interface with the criminal law. We've looked at how to determine someone's ability to make a decision, emphasizing that perhaps look at contact before sex. And if there is a situation, and it's these sorts of cases that often go to court, where someone lacks capacity about contact but has capacity around sex, then the courts encourage us to provide a support plan that enables the person essentially to find safe environments by which sexual relations can then occur. I've just quickly given you here 3 really helpful tools that we often use, and you might be familiar with them. And then there's also some useful resources on this slide as well, a number of which relate to the use of the internet, which of course nowadays is one of the popular ways in which to have contact and find sexual relations.